pre-trial proceedings for the criminal case of former Vlakpas Askari, that's Ephraim Mfalapitsa, will get underway in the High Court sitting in Johannesburg today. Eustace Madikela and Ntingo Mataboge and Mfanyana Nhlapo were killed in a planned explosion back in 1982. A fourth student, in fact, that's Zandisile Musi, was seriously injured. Now, Mfalapitsa had defected from Umkhonto weSizwe, allegedly lured the students to a pump house under the guise of giving them training. Moray Hathon is the attorney for the COSAS 4 families. He joins us now via our video link for a sense of what we know about this case and perhaps what we can expect when pre-trial proceedings get underway in the High Court sitting in Johannesburg today. Moray, it's great to see you. Thanks very much indeed for making time for us on this Friday morning. It's an incredibly important story considering the conversations that have happened around apartheid-era crimes and the lack of progress we're making in essentially ensuring there's justice for the affected families. So perhaps let's start there. What do you reckon is of most importance for the families as we gear up for this particular trial to get underway?
I think that the most important thing is to make sure that that not only Mfalapitsa stands trial for this murder, because his security branch handlers, who were white security branch officers, have not been charged. He has apparently signed a confession, which no doubt makes a prosecution easier. But we believe that there is evidence, admissions and implications by those senior officers who are white before the TRC. And our view is that those admissions and where they implicate others in the applications they made at the TRC for indemnity, that evidence is in fact admissible. So we act on behalf of two of the families of Eustace Madikela and Mfanyana Nhlapo, and we have in fact briefed counsel. We have briefed counsel for his view on whether the evidence and admissions made at the TRC can be used as evidence against those senior officers on a charge of murder. So we believe it's very important that it isn't just the Askari, who obviously was deeply involved, Mfalapitsa, who was an informer, who was deeply involved in, as you say, luring them to that pump house and giving the signal when he left the pump house and having left it locked and having left explosives there, which he was alleged, which he was training them in the use of, on the basis that they believed that he was an MK person, and they didn't know that he was an informer, of course, before at the time, and they were looking to go into exile for training, and the plan was to get them into the pump house. And of course that plan was hatched by the senior officers, who in fact were, some of whom were present on the scene at a distance away. And one of whom in fact was an explosive expert who set off the detonation, which killed 3 of them and wounded Musi, who is still alive.
Sure. This case is also coming in a context where I guess we can say with a whole lot more confidence now that there was some kind of political suppression by the NPA and the Hawks to suffocate these apartheid-era crimes from essentially being ventilated in court. What reasons did you get around why the other, I think it's 4 security branch officials are not necessarily in court also being held accountable for this crime?
Well, I think possibly that the reason is that the NPA hasn't fully accepted, and we will provide them with it. We have provided them with an opinion 5 years ago, and we will do so again from counsel, to the effect that they believe that admissions, you see these 4 or 5 officers, including Mfalapitsa, made application to the TRC for indemnity or for against prosecution of that crime. They failed. The TRC refused to give them indemnity, with the result that they are liable to prosecution. I think the problem lies in the fact that the NPA has never accepted that the evidence which they gave voluntarily before the TRC is admissible in future court proceedings.
Right.
Our opinion is that it is admissible. They've never accepted that. The evidence which is not admissible is evidence where on special application, applicants before the TRC were actually were actually compelled to give evidence which they otherwise would not have given. That category of evidence cannot be used in future criminal prosecutions. It is not the evidence freely given, which they did. They were not compelled to give this evidence. And this is a common device in commissions of inquiry, that evidence freely given is admissible in court. The NPA seems never to have accepted that, and we hope that they now will.
Right.
As I say, we are getting an opinion from counsel as to whether the admissions and the implications of their colleagues by each of them implicated each other, of course, in the setup of this crime. That in fact this evidence taken together would amount to sufficient evidence beyond a reasonable doubt for the conviction of those officers. The NPA needs to move on that issue,
right,
and they haven't done so yet.
What you've also mentioned in our discussion now is that you're expecting some kind of confession from Mfalapitsa, who is the Askari who's essentially going to be in court today. To what extent can that confession allow you to also broaden the scope around who can actually be implicated in court? In other words, how important is it that the Askari here has essentially conceded to giving some kind of confession?
Well, I don't know what's in that confession. We don't know. We haven't seen it. The problem is evidence against. He's made a confession of his own. I do not think it would be testimony against the others. They haven't been charged, and we don't know what's in that confession. But we would have to. The evidence, he would have to be willing to go beyond the confession and actually give the evidence against his handlers, the superiors, under oath in court, orally. He would have to be willing to do that. And one would imagine that he hasn't given that indication yet, because if that was the case and he implicated the others, then surely they would have been arrested and charged by now.
Right.
So we don't know what's in that confession, and we don't know whether he's prepared to take that extra step.
How likely is it that he will take that step? Because what we've been told is that, in fact, the lawyers representing him also happen to represent the security branch members who are implicated in this matter.
Yes, we've heard that too. We are considering the propriety of that, because there isn't necessarily, that it would appear to be, there isn't necessarily there may well be a conflict of interest between Mfalapitsa and his handlers. So we're looking into that issue. I can't say more than that. We've in fact briefed counsel on that question as well, and we're waiting for an answer.
All right, fair enough. Thanks very much indeed for an idea of what to think about for this incredibly important case. Pre-trial hearing set to begin in the High Court sitting in Johannesburg from today. A first step, I imagine, in many steps ahead to, at the very least, getting justice for the families of the COSAS 4 victims. Thanks very much indeed for that. Moray Hathon is the attorney for 2 of those 4 families.